to partake in a parent-teacher conference in her stead, of her firing the former long-term nanny, and of her going through between 11 and 13 nannies between the time of their divorce in 2009 and the time of this trial. Her discredited testimony regarding her prior parenting plan with Mr. Glover, and her shocking, Your Honor, deposition testimony about her threatening witnesses who were going to give testimony adverse to her, and her admissions. I would cite to you further, Your Honor, the guardian ad litem report and the statutory factors we talked about in the closing argument under 1993 in the case law, which clearly supports the court's verdict. I would say this further, Your Honor, in regard to this issue of recusal that keeps being raised. I believe she's pandering to the press and to the media, hoping that they will not research the facts and the law in regard to this area, rather than taking responsibility for the facts of this case. And I would say this. The law is very clear, and I cited to the court the Christensen case. The Christensen case, which is in our brief, says very clearly that a motion for new trial is not a proper vehicle to raise a motion to recuse. And it makes perfect sense because the motion to recuse has to be timely and has to be of certain substance. I would cite further in response to this continuing drumbeat regarding recusal, the facts, and these are in the court's orders which have been entered. Both sides' lawyers had former firm and firm members who gave money to the same re-election campaign. This has been public information since the year 2008 for both sides. The lawyers that contributed to that particular campaign, there were over 75 that contributed just to that one event, which I did not host. Both former firms had associations with that event by having members at that event. The issue about me being an executive member of your committee, I would challenge them to find that anywhere in the record because that's not true. And I would also have the persons who are interested in this issue note that the State Bar of Georgia, the Judicial Qualifications Commission, the Supreme Court of the United States have all approved the practice of lawyers and law firms contributing to campaigns. Lawyers who in fact appear in front of those judges. So I would say this, Your Honor, there's no basis in law. As the court noted in one of these orders, now as I understand it, there's been 5 times this has been raised. There's no basis in law. There's no basis in fact. The motion was not timely filed. And just like their issue about not following every single direction you gave them in the scheduling order, every direction, they did not timely comply. I would say this as well, Your Honor. The court has done nothing wrong. The court has followed the rules and procedures of the bar, of the JQC, and of the State Bar of Georgia. And any suggestion to the contrary just remains offensive. The most
and address the attorney's fees issue as well. I will state before the court that the most important issue before the court, as far as Mr. Raymond is concerned, is a supersedious issue. And he wants the children with him. The court decided that issue already. The court decided on August 24th the best interest of these children. And on August 24th, the court said that it is in these children's best interest to be in the custody, care, and control of their father. Almost 2 months have passed, and we're operating outside the best interest of those children. And there's no reason for it. This court has the ability to, 1, issue an order which states that the children should be in the custody of their father, irrespective of any motion for new trial or motion for appeal. You have that ability. And I filed a motion on August 31st which said that you had done that in your order. Because under Frazier, Blackmore, welcome. The requirement is simply this, Your Honor, that you in your order state with specificity the date that the children are to be transferred, and second, that it's in their best interest. You decided that already on August 24th. The children should be transferred to the custody of their father in Stanton. He has done everything possible to assure you that what you said to him on August 24th, which is that he would have custody of his children, that he is situated to have custody of the children. He has changed his schedule. So only in Ms. Foster-Raymond's world is it a bad thing to tell the court, I'm not going to go on tour internationally because you've awarded me custody of the children. I have an opportunity to be with my boys, so I'm changing my schedule. Only in Ms. Foster-Raymond's world is that a negative. Only in Ms. Foster-Raymond's world is it a negative for him to obtain a position which allows him to not have to travel abroad. It may require that he travels certain times a month, and I think that there's only 44 days that he has to travel for the 2012-2013 season. But it may be that he has to travel from time to time. But we all knew that when we walked in this courtroom. We all knew that when he entered into the settlement agreement in 2009. You knew it when we walked into this courtroom in April, that Mr. Raymond, as a condition of his employment, has to travel from time to time. That he does not have to travel abroad and will be available to these children, not in the future, but now, present day, a present parent. Only Ms. Foster-Raymond's world is that a negative. He's ready for the children. You said it's in their best interest. We ask you today, please, Your Honor, to go ahead and enforce your orders and allow the children to be transferred to Mr. Raymond. And enforcing your orders is really important to us because the respondent doesn't abide by court orders. She doesn't abide by scheduling orders. And she doesn't recognize the finality of this order, and will not. And unless you enforce your orders, Your Honor, we will be here again and again and again. There has to be some end here. There has to be some resolution. You decided the best interest of the children, and nothing has changed except Mr. Raymond has done what he said he was going to do, and he's made himself available. He can't be penalized for that, nor should he. Let me go on to attorney's fees. First and foremost, I have to say, Your Honor, that again, the respondent is not entitled to an award of attorney's fees. And you might think there's a financial disparity, and so automatically Mr. Raymond ought to be responsible for her fees. But this court in its modification order said you have 10 days, either party wishing to make a request for attorney's fees, you have 10 days to make that request. That request was not made, and not for the first time in this action. They failed and refused to meet a deadline. They didn't meet their deadline. You don't have the ability then to award them attorney's fees. It's an out-of-town filing. Now, Ms. West would like you to believe that because she filed a motion for new trial, that there was some tolling of that 10-day period. And that's simply not true. Because the automatic stay only relates to the final order. You specifically reserved issues relating to attorney's fees and child support. You took them out of the order. You said they're not final. I'm going to give you 10 days to give me a motion or a brief or a letter with regard to attorney's fees. They missed that deadline. They can't be awarded fees. You should not award them fees, and I'm asking you again, Your Honor, to please enforce your order. Otherwise, we will be here again without end. They've requested, if you decide to give them a second bite of the apple, which is their request, if you decide to do that, then there has to be statutory authority that allows them an award of fees. Moon v. Moon says that it's clear. So in her motion that she filed in open court on September 11th, Ms. West requested fees under 196-2, which can only be allowed in this type of modification action for contempt matters. Now, first, Your Honor, you have to be reminded that you already awarded them fees under 196-2. And Ms. West would like to separate that from this action, but this action is the action that's prevailing before the court. It's pending before the court. And at that time, opposing counsel, first opposing counsel, there have been several, first opposing counsel filed an answer and counterclaim to our request for modification. This answer and counterclaim had 5 contingents of contempt. 5. In May, when we came in for a status conference, they requested attorney's fees in order to investigate and uncover their contempt allegations. 5 of them. We object to our motion title. They've already been paid. They were paid for 5 allegations of contempt that were pending, only 2 of which the parties were actually able to, that she was actually able to prevail upon. And those 2 were notice provisions and, I believe, joint legal custody, the right for information and to confer and communicate. Even if you say that that $25,000 is not enough money, and you say that it is, then you have to go to the necessary elements of 19-6-2, which include that there has to be an ability to differentiate between the matters, the legal services provided. How are we to, from her billing, I'm sure you've seen it, it has six-day time frames, and consistently there is a copy of words consisting of analyzed and conferred. How are we to determine what legal services were provided for contempt matters? How are we to determine whether or not they were provided for contempt matters that she prevailed upon or contempt matters that she didn't prevail upon? Because in her modification filing, she had 8 contempt counts. 8. She prevailed upon 4, 2 of which were already in the answer and counterclaim, and 2 of which were Saks Fifth Avenue and a nanny payment where she asked for $34,000 and you gave the nanny $1,300. That's it. The nanny issue, Portia Williams. She was employed before the 2 new counsel were ever employed. So what work could they possibly perform with regard to Portia Williams? I contend none, minimal, if any. The issue with regard to Saks Fifth Avenue, we were aware of that issue, or what the nature of the issue when the modification was filed. No effort ever at any point in time to resolve any contempt allegation by this respondent. Apparently, the Sears issue, the Saks issue came up in the summer. Again, before these 2 attorneys came on board. So what work would they have performed with regard to those contempt allegations? I contend very little, if any. Further, Your Honor, Ms. West said during trial that there was a mathematical impossibility for Mr. Raymond to parent these children. So how are we to determine what legal services went into uncovering this mathematical impossibility versus those that were utilized to prove that he was in contempt of any notice provision? And I submit to you, Your Honor, that there was no contempt of any notice provision. I respect the order of the court. The court held in its contempt order that there was one instance where Ms. Foster Raymond said that she didn't know the children were on the red carpet. She didn't know that they were in Los Angeles until she saw them on the red carpet. You look at my motion, my response to the motion for attorney's fees, you will see correspondence from her counsel saying, we approve travel to Los Angeles during those very same dates. By way of mitigation, Your Honor, I'm asking that you look at that. Because at no point in time, from the point that we filed this claim in January of 2011, did Mr. Raymond have any parenting time, any travel with these children without notice to Ms. Foster Raymond. At no point in time. That was governed through counsel, that was governed through the guardian ad litem, that was dictated through schedules that the guardian himself put into place pursuant to their travel schedules that were produced at his direction. So when she says to you, I didn't know what his schedule was, that's simply not true. It couldn't possibly be true. And she knew at all points in time, and if in fact she had the expense and resources to try to figure out where he was, it was not where he was when the children were with him, because she knew that at all points in time. And the guardian's recommended parenting time was in place from May until January. May 2011 until January 2012. At that point in time, she refused to enter into any further agreements with regard to parenting time. So if she had to look for him, she had to figure out where it was because she refused to abide by the guardian's recommendation with regard to parenting time. Even though in her own petition, she said there's an issue with the settlement agreement and the parenting time and it needs to be modified. But she refused to abide by the guardian's recommendation. It's a problem. You're not able to determine what legal services were tendered for what, whether or not it was for the modification upon which we prevailed, their modification which actually failed, or the contempt claims, some of which they prevailed upon and others which they didn't. Look at the billing. There's no way for you to differentiate. We go then to 19- I'm sorry, Your Honor. Another essential element was financial circumstances. It's mind-boggling that Ms. West says that our contention is that our client never showed evidence of his financial circumstances. When the reality is that we contend that she never showed evidence of her financial circumstances. And what's so interesting about that is that she filed a complaint for modification, that she filed a request to increase child support, and she, in her case, and she's never presented one iota of evidence with regard to her financial circumstances. Not one. She didn't produce a financial affidavit until I filed my motion objecting to the request for attorney's fees and stating that there was no evidence of financial circumstances. And after that, she amended her motion, and she attached thereto a financial affidavit. Now, the statute says that you have to look at financial circumstances introduced during the trial. That wasn't introduced during the trial, so I submit to the court that you can't look at that. We have no evidence of her financial condition, except the following. She says that in the year after the divorce and prior to our filing modification, she established 3 businesses and that she was a successful stylist, and pursuant to that success, she required a Saks Avenue car. Her financial affidavit doesn't say anything about her work as a stylist. It says that she works in retail. And her income is so nominal as to fly in the face of any reasonableness. It's not credible. It's simply not credible. And so, because you're not able to look at the financial circumstances of the parties, you are not able to award attorney's fees based on 19-6-2. I go then to 19-6-3, which is the second statute that Ms. West listed in her request for attorney's fees.
Your Honor.
And that was an error.
Your Honor, Ms. Brown, Ms. Brown is now 6 minutes over. I do request that I be allowed also the same amount of time as she is.
I agree that you are 6 minutes over, so we're going to let you off.
All right, Your Honor. I will say this, that Ms. West went over, that we kindly allowed that we did not object. The court would take notice of that. However, under 19-6-3, that was not a valid statutory authority for the award of attorney's fees. In my response, I kindly suggested to the court that perhaps she meant 19-9-3, which allows for attorney's fees and a modification. She didn't prevail on her modification. We submit to you, Your Honor, that that modification was a thinly veiled attempt to get around the fact that they failed and refused to abide by their scheduling order and did not produce a list of witnesses, didn't produce a list of exhibits, didn't amend their complaint within 10 days after your requirement that they amended, didn't do anything that was required under the scheduling order. Yet, instead of us being allowed sanctions, Your Honor, they were allowed to introduce into evidence document after document after document that we had never seen before, never ever seen before. Meanwhile, we presented in court and we produced only the documents that we issued, indicated on our list of witnesses. List of exhibits. We introduced only the witnesses that we indicated on our list of witnesses. Timely file, Your Honor. They didn't timely file anything, and they were allowed to introduce that evidence. We objected to it. We requested that for modification be dismissed because the intent was only to get around your scheduling order deadlines.
I believe your time is up.
Thank you.